All right, Brian, I assume we're on. Good afternoon, everybody. You're on with the Wilmick Free CLE Fridays program. Brian Anderson and I'm Joe McCarthy. We'll take a little minute to introduce ourselves. But we did want to say thank you for being here. This is the last installment of these free Friday CLE programs, at least for the calendar year. Sort of hoping and anticipating that we'll continue to do these in the future. They've been pretty well received, and we've had decent sized groups each time we've done them. And the pandemic has caused us to think of new ways to deliver information and be out there and do what we can for especially our policyholders. So this came up in the spring or maybe the summer. We started kicking this idea around, and so far so good, at least from my point of view. I'll continue. I'm Joan McCarthy. I'm the Vice President of Underwriting and Claims at Wilmick. So I get to work on both sides of the house, so to speak. And prior to joining Wilmick 10 years ago, I was both a trial lawyer in Milwaukee, Madison, and then also worked at another insurance company here in town in Madison. When I worked for that insurance company, I had the chance to handle mediations all over the country. So I got to see a lot of how law is practiced in a bunch of different places and in different venues. So hopefully we bring some insight into that. If you have questions, you can send emails to Brian's email. I believe you've got a prompt out there to do that. That's Brian with a thumb up there. And then we will be able to see those questions. Unfortunately, there's no way for us to with this many people online, to have you ask questions, sort of at the same time as we're going along. But please feel free to send an email in, and if we miss it or we don't get the chance to answer it during the program, we'll get back to you. Brian, you want to introduce yourself?
Yeah, so it's Brian. If there are questions, and feel free, it's Brian, BRIAN .Anderson, SON @wilmick.com. The other thing Joe mentioned, I'm thinking before I introduce myself, but with regard to these programs, we've tried to cover as many different areas that we think might be of interest and helpful. This is the fourth installment, but please, another thing we would really appreciate, and I can't promise we'll do it, but if you would give us feedback about things that you might want to see, because I think we'll keep doing it and I'm doing it this format because it's easy for you and it's easy for us. But topic ideas would be great, because we're going to try to we want to do things that will be helpful to you, useful, and we don't want to do the same thing again if there's something that you would like to see us cover. So that's that. I've been with Wilmick for a long time now, so my previous history isn't as relevant as it used to be, but I started out in general practice, all areas of the practice of law with a firm in Janesville. And that was great background because that's what we insure, all areas of the practice of law. And then I worked in an insurance company, and before this, and also did personal injury plaintiffs work, which is an area that we see quite a bit more claims than we do in the defense side. But this program is on legal malpractice risk for the defense lawyer. And it's not an area that we see as many claims, and we're not going to try to scare you with claim stories, but there are some relevant issues and concerns that need to be addressed. And the stats will tell you that I included, hopefully you've had access to the outline that we put together. If not, we'll go through it. But the area of legal malpractice claims against defense lawyers, surprisingly to Joe and I, and was perfectly timed for this program, but was the biggest increase from the ABA study that was done in 2015 and then done again in 2019. It increased more than any other area in terms of percentage of claims made against defense lawyers. So it's not to be I mean, we're not making it up that there are claims against defense lawyers. There are. And as a matter of fact, it's 5% of all the claims that were asserted in the 2019 ABA study.
Right.
So it's, and we'll go through some of that, and I'll be interested. Joe did defense work before too, so I'd be curious to see some thoughts about why and what are the issues why are these increased, and what are the issues causing the claims. I will say one quick thing, and for those that have attended other of our programs, estate trust probate is leading the way for Wilmick this year and has the last couple of years. Family law, personal injury plaintiff, criminal defense are all more frequently areas that we're seeing claims in, but this program is designed and will address legal malpractice risk for defense lawyers. So I gave you the quick summary that 5% and the increase of the claims. And I guess, Joe, we have a couple of theories as to why, but what might, in your mind, be the reason why insurance companies might be more willing to sue defense lawyers? Do you have any great ideas?
You know, I've been thinking about it, and I think it comes down to, you know, the landscape's changing everywhere, and that's no different for, I'll go back to my own experience. It's no different for insurance companies than it is any part of any industry, right? I mean, I'm sure that the turnover in insurance companies is dramatically different than it was 10 years ago. And I think that you have people with less experience potentially as a claims handler inside of an insurance company than you did 10 years ago. And with that, there's a heightened expectation of communication, more so today than in the past. And you have to be more sensitive to that. You know, as we went through the outline, as we put the thing outline together and looked at it, it struck me that there's a number of areas talked about in the outline that it goes across all areas of practice, not just insurance defense or defense work. You know, the communication with your client that's talked about in this outline, that holds true no matter what you're doing. And communicating at your client's level of understanding is key. But more so than that is because most clients, if they don't understand, they'll ask, say, hey, I don't know what that means. Please tell me. But I always tell, particularly younger lawyers that we talk to, you need to be able to talk to your client on their level, not on a lawyer level. Don't talk about what kind of motion it is and all that. You need to talk to them on their level. But where we see claims happen is when lawyers fail to keep their clients apprised of changes in the case as a case develops, keeping them regularly informed. And we talk about it all the time, Brian, and I think this is probably because it holds true in all of our claims. It's the level of communication that you have with that client and how well you keep them informed. And it's not, and having been, I was a claims manager for an insurance company previously that wrote in all 50 states. And the key for us inside the insurance company was being kept up to date on developments. I mean, you know, we sort of expected communication from our defense lawyers at least once a month. Even if there's nothing happening, write your client, tell them, hey, there's nothing going on. Don't worry, we haven't forgotten about you. Here's where we're at. We're still sitting at this level. We're waiting for information to come in. You know, on the, looking at who your client is also a big piece of that, because for the individual insured behind an insurance policy, it might be the first time they've ever been involved in a legal matter. It's the first time they've ever had to deal with a lawyer. And then they don't realize that it takes months sometimes to gather information, go through the discovery process and all that. But I think the overall umbrella, Brian, if I had to look at it, would be, communication with the client so that they understand it, and how quickly you're making them aware of developments in the case, good or bad.
Yeah, I think the relationship piece definitely has saved some defense attorneys. They have a long-standing relationship with an insurance company. And Joe's right, the personnel changes, employees change and turnover. There may not be that familiarity and willingness to let something slide that we've had. The other thing and I'm glad Joe pointed it out, this is a legal malpractice risk for the defense lawyers, the program. But Joe pointed out the communication, that doesn't apply just to defense lawyers. Conflict is a big concern in this area. That goes across the board. The other thing that's interesting in this area is where there may be a dual representation and you may be paid by one client, but offering services to another. And that has been an area that has caused problems in family law cases and estate planning cases. Who's the client? Who are you answering to? Is it because they're paying the bill? Who's directing you to do what? So I'm just saying that if you don't do any defense law, that's okay. This program has some things that we'll discuss that will hopefully merit some consideration for you, because we do seek claims. And I think estate planning, family law come to mind for sure, where dad's paying for daughter's divorce, son's paying for mom's estate plan. Who's the client? Those are fraught for peril when there's a problem down the road and the attorney gets questioned about, who are you looking out for here? Or was it just because X was paying your bill? Those kind of things. And that's certainly an issue of concern for defense lawyers. So anyway, there are some universal themes but I think the communication is the overriding key to protect yourself. And it is in this area too. Right.
Yeah. The other area that we talk about that sort of it's not a parallel to, but you build on that communication piece of it is, sort of documenting for your file and for your client what you talked about. And, as guys who work inside of an insurance company and talk to lawyers all the time about case developments, we don't necessarily expect a letter every time we have a discussion with defense counsel, but and the communication with the folks inside of an insurance company, it's a little bit different because we understand where the case is and where it's going. Your client might not. So when you're communicating developments to the client, the insured, or that untrained individual out there, not legally trained, documenting what advice you've given, what developments you've told them about, and actually putting in your file is a big deal. It'll save you potentially, it'll help us talk to the client if there was ever a malpractice issue, but also it allows you to go back and say, okay, here's the letter I did write to our client saying, remember we talked about this on X date and here's what I advised. Those sorts of communication are invaluable for us and for you, and help us defend malpractice cases all the time. But the key to that is you can show that you were keeping that client up to date as best you can, even if you're just writing a letter saying, hey, I'm just documenting that we talked today and here's what we talked about. What do you think, Brian? How often do you see that in failure?
Well, the interesting thing, I was out practicing and I did plaintiff's PI work, and I would hang up the phone and move on to the next file, and I didn't have notes. I did the best I could, but I was just scrambling. But an insurance company, every contact is put into a case note very carefully. and it's set up so that everything's documented perfectly, so that if I were to not show up to work, Joe could open up the case file and know exactly what's going on with the case. I only say that because we have an interesting clientele. Obviously, the claims we see at Wilmick are all involving a claim against a lawyer. And this isn't I think we have excellent counsel, but even our counsel, we send out post-claim surveys after every claim closes, just to partly check on us and I mean, to pat us on the back. We generally get solid marks for ourselves because we have a system in place where we send out a letter acknowledging the claim. We send out the policy information. We keep our insured informed in all aspects of the claim. We try to, and we check ourselves with the survey. Occasionally, our defense counsel will get a little lesser, not often, but there'll be a little sway where the insured didn't feel they were kept as attuned to what was going on as like Joe just mentioned. And I think the problem is that for defense lawyers is there's a familiarity with that we hire the same attorney often to handle different matters and frequently throughout the year and years. But that one, as Joe pointed out, maybe there's one claim against a lawyer in his or her career. And they maybe, even though they're a lawyer, they may not understand exactly what's going on, or is there a mediation, or am I going to be deposed, or what's happening with discovery. So the point being, you're never wasting, it's not a waste of time, and it is important to the client to send that note. And even though it seems a little bit, I think sometimes defense lawyers may be reluctant to, I don't even want to bill my client for that. We talked about it on the phone. It is important, it's worthwhile doing, because that's something that as Joe pointed out, nothing happening, here's why, the judge has recused himself. We're not expecting to have a scheduling conference for 2 months. I know that I talked to the defense attorney about that. I understand that. I put it in my notes, but maybe that wasn't relayed to the client, in our case, the lawyer who's being sued. And they just feel a little apprehensive or uncertain about what's happening, or they may not be used to litigation. So it's a long way to say, make sure you're sending that communication, and especially to the customer, client, policyholder who you're representing, because they're the ones that may be feeling unsettled or disappointed that they feel like I didn't really realize what was happening in my case. And then that gives them a forum too. If you send, here's what's happening, I don't expect anything for 2 months. When we do, this might happen. They can call or write you a note and just feel better about knowing the status. And sometimes just getting off track a little bit at the early stages or at any stage during the case can cause a problem that amplifies down the road when things do develop a little differently than one might expect. So that's and I'm not saying this, I'm saying this with full benefit of hindsight, sitting as a claims person at an insurance company, knowing that, yeah, it's a pain in the neck. I realize, and you feel like, do I really have to send the status note? I'm not saying everything, but it's never, put it this way, it will never be frowned upon that you send a letter just saying, don't expect anything for 2 months. October 3rd is the next scheduling order, and I'll get back to you after that. The client actually appreciates that, and it sets the tone about what's happening.
Right.
Yeah,
I agree. It's an interesting, as an insurance defense lawyer, you are in an interesting position that unless you do that work, you might not ever be in the position where you are to have the insured's best interests at heart, but it feels like you're taking direction from the insurance company. The insurance company's paying you. But that's built in, our SCR rules allow for that sort of relationship in that particular instance where there's an insurance company who's hired you as defense counsel to, address the claims being made against a policyholder. But it is, it can be a difficult position to be in because you're like, okay, who am I taking direction from here? And honestly, in the 10 years that I was doing insurance defense work, as a lawyer, trial lawyer. I don't know that I ever had a policy holder argue with me or with the insurance company about strategy, about where we thought it was going, anything like that. Communication with that policyholder may have made the difference, but I think folks out there are willing to listen to your advice and take your lead on things, or the insurance company's lead on things. Part of the outline talks about, who gets to make that decision. And most insurance policies provide that decision-making power to the company, and as part of the insured's, not obligation, but it's part of their agreement that for coverage, you're going to let us pick defense counsel, you're going to let us make decisions about whether or not a case should be settled, and sort of that piece of it at least. So if you ever have questions, look at the insurance policy behind the case to see what language is there. But there are times when you feel, okay, who am I answering to here? I've got the plaintiff, I've got the judge, I've got the insurance company, and I've got my policyholder who I'm trying to answer to. But so you do have some protection, at least through the agreement in the insurance policy, that does give the company power to direct defense. At least
there is an SCR rule on point that allows, it's the insurance defense exception, SCR 20:1.2E, which allows you to accept compensation from one source, the insurance company, and defend the interest of the policyholder and the claim. But the one catch is, which we've been saying in round and round, is that you have a duty under that relationship to make sure your client, and I mean clients plural, are reasonably informed. So that's the rub, I guess, and that's what I was dancing around in my long story to begin this thing. So yes, that's allowable, it's acceptable, it's within the SCR rules, but the duty on the lawyer then is to make sure all clients are kept reasonably informed of all developments. So it's not just good customer service, it's an SCR requirement when you enter into that type of relationship. So, well, Joe, we've kind of been bouncing around, but I think we're going through the conflict and the insurance defense exception. We've covered that. One of the biggest issues, I think, and we'll get into it once here maybe, and then go back to it again, is the issue of when you're representing a client and the insurance company, and all of a sudden you recognize that this claim may be worth more, or potentially the exposure is greater than the insurance policy limit, so how does a lawyer navigate that situation?
Yeah, I know. I think that, I think best practice is to err on the side of telling both the insurance company and the insured exactly what you think. You have an obligation to exercise independent, professional judgment. Sometimes the insurance carrier won't agree with your judgment or evaluation. Sometimes the policyholder might not. But I think you still have the obligation to do that. And I think that I always looked at it in terms of, I'm better off telling everybody right now what I think, so that, a policyholder, if they are going to be exposed to something beyond their policy limit, they have the right to hire independent counsel and get somebody involved for them to help defend, that exposure to them. And I think that, at least in Wisconsin, you have an obligation to do that. And it'll be better received in the beginning than in the end, where you find out they're beyond the policy limits. But I think, before this program, Brian and I were talking about, I remember seeing $25,000 limits on some auto policies, and boy, you could barely have any medical treatment at all. And all of a sudden that policy's gone. But those are the kinds of things that, in the beginning stages of defense of a case, you've got to understand, okay, how much, what are the limits on this case, and what do we think the exposure is? And then sort of the obligation to do as diligent of an investigation into the case as you can, sort of as quickly as you can, reaps benefits down the road. One, it'll allow you to give a heads up to the insurance company or to the policyholder that, here's what I think this case is based on my experience and what the facts are here, and what the exposure is, so that folks have a chance to react and prepare for that. And you'll just be better off down the road if you do that early.
Yeah, I agree with, and Joan brought up a point, which I worry about on the other end of things, because we've seen it more than a few times where the plaintiff's attorney doesn't understand or even ask what the limits are until it's either they're way into a case that they've spent a lot of money on and there may be not huge limits. I mean, I think that's worthwhile finding out right at the beginning. And obviously, too, the defense needs to know that as well. If you're working with a $100,000 policy, you might handle the workup differently than a $10 million policy. And obviously, you still want to make a judgment as to the value of the underlying claim, but you have to first know the limits and work backwards. But the point on that is that and I know, Joe, I think we did this program a few years ago, and there was a certain adjuster that came to mind that we both knew from a carrier, where he thought he was a hotshot, and he would call the defense attorney and say, "You're not taking any depositions, you're not going to do any discovery, you're not doing this, that, and we're just going to try this case." Well, how is the insurance company and the policyholder going to make an assessment as to the value of the case if you did no discovery? And if that's the case, as a defense lawyer, is that a case you even want to take, if that's the direction you're operating under? And secondly, if you do, you better write a strong letter right out the beginning and say, "I can't evaluate this case without doing discovery. You've told me I can't do this, that, and the other thing, and I have managed care of a legal defense attorney in the outline." I hope that's an exception to the rule, but the guy's initials were TB, Joe, just so you know. But I mean, I make a joke about it, but and I know sometimes policyholders and or the general public think, well, why does defense lawyer have to do that? I mean, they're just trying to crank up their bill. No, they're trying to give the insurance company a fair assessment of the value of the case. And sometimes you do have to do some work on it. It's not just because they want to take a deposition or talk to some witnesses. They'd rather not do that stuff. They have other things to do, but it's so important to the insurance company to have an evaluation that they can then work off of from that point forward. And to do so, at least to do the insurance company the service, you need to do some discovery most often. And that's why you do that. So you're not under the pressure of the day before trial thinking, "Oh my gosh, I didn't look at this, that, and the other thing." You guys got better, or the day before mediation. But it's helpful for the carrier to get the reserve in the right realm and know what they're dealing with by doing that legwork.
Right. Well, I'll just respond, Brian. That's why I started by saying you exercise your independent professional judgment, right? Because you do have folks in the industry out there like that. And, it goes beyond, answering to that one claims individual with inside an insurance company. You've got an obligation to the entire insurance company, so that there would be no argument that they were not acting in good faith to protect their policyholder. So you've got, when I said it becomes an interesting position where you feel like you're in the middle of everything. When you handle a case where that becomes an issue, you really feel like you're in the middle of everything, because you are looking to protect your client's interests, so that there's enough limits there's enough coverage, but you're also looking to protect the insurance company so that they are prepared and informed as much as they can be so that they can, truly evaluate a case. This might be a good segue, Brian. As having worked inside of insurance companies, one of the things that I always talk to the folks that I work with who were handling the cases around, not just with, at this company in Wisconsin, but previous company where everybody was spread across the country. It matters that you get an early evaluation from defense counsel so that you can look at reserves, and so that the insurance company, a part of the insurance company being prepared in a case is that they have an evaluation and set reserves so that that file's got appropriate money on it, so to speak. The insurance company will do their own evaluation as defense counsel provides them with information, but they also want to know what the defense counsel thinks of it, and what that claim handler inside that insurance company might not be particularly aware of what's the venue like in Green Bay compared to Eau Claire or Kenosha, and that's why defense counsel are so critical in saying, in this county with this case, the exposure is this. It can vary dramatically whether it's in Madison or Superior, so that matters. And all of that plays into the insurance company setting reserves where they are, and so that they can anticipate then what the exposure is within a case, and then on all of their cases as well. So it's critical information to provide to the carrier right away, as quickly as you can. But then you also have that obligation as cases develop to, change your opinion. If developments come in, you get evidence in that makes the case worse, don't try to fix it. Don't try to go get other evidence that's going to counter that. Tell your client and tell the insurance company right away, hey, this is a bad development, or we've had something happen that's a good development. And if it impacts your evaluation or what you think the case is worth, then tell everybody. You'll be much better off down the road if you tell everybody right away.
One thing I think I left off with, I wanted to bring up on this insurance coverage thing, because we've seen a few situations where an insured has privately retained defense counsel, and defense counsel later discovers that, wait, you could probably tender this to your carrier. I think one of the obligations of a defense attorney or any attorney would be, is there insurance coverage available? And I know there's hey, I want to take the case. This is a friend of mine. But if they have insurance coverage and you didn't advise them to place their carrier on notice, you could be criticized, and that it could actually impact their ability to even have a claim covered. So, and especially our policy for legal malpractice is a claims made and reported policy. So if you need to report the claim in the policy period in which you first are put on notice of a claim or potential claim. And there have been a couple instances where an attorney wants to have a friend of theirs defend the case, and that's maybe what you want to do. But I'm saying, as a defense attorney, you better at least advise your client that, hey, you may have coverage available. I'd love to help you, but I don't want to jeopardize your coverage. And I can see a legitimate claim or grouse down the road if there's no coverage and that you never advised them to tender it to their carrier. That's one. And number two, there may be other insurance policies or another potential source of coverage that at a former firm or with a business, et cetera. So I do think one of the obligations of the insurance defense industry would be to make sure all relevant policies are put in play, or at least discussed with the client, so that you're not exposing them personally to a matter that may otherwise be covered by insurance.
Well, and every policy has, within the terms and conditions, the obligation of the policyholder to report it. If they want to make a claim against the insurance policy, obviously you've got to tell the insurance company. And as we tell our insureds all the time, if you have something come up, talk to us, talk to Brian and talk to Matt. Let us help you handle that. That other insurance company, or if you're, helping defend a family member or a friend, and you're thinking, boy, there might be insurance for this, that insurance company wants to help too, because they don't want to be exposed unnecessarily to something that they might be able to help defend and to sort of repair along the way. But, it does happen. We see it happen every now and then. And sometimes it's so obvious. I've said to Brian, this is a clear case of this guy finally went and hired a lawyer, and the lawyer said, you should turn this into your carrier. Yeah. I mean, it does happen. So yeah. It is something that you should be looking for and thinking about if you're out there defending folks, and that might be an issue, because they have an obligation to tell their insurance company and get them on board if they should. And by the way, it might really help out your client to have another insurance policy out there and another set of eyes looking at the case and helping out. I don't know, Brian, in your plaintiff days, how hard was it to explain coverage to your client, and did they understand your clients in that setting, do you think?
I don't know if this is what you're getting at, but what I'm amazed at times is we see a claim come in whereby an attorney was crazy writing about the fraudulent intentional misconduct of the attorney, and it just works itself right out of coverage because there's no claim of negligence anymore. Right. So, I mean, I think that's why, and I get it. I get it, Joe. And this is why I don't know if this is what you're getting at. I think the client's really angry and wants to see some nasty complaint that really rings up the guy for punitives and otherwise. But I think that's where and that's a different setting, but the attorney has to say, listen, if you want coverage, we need to assert a claim that would be covered. Understanding the insurance industry, you need to have a negligence. Insurance companies don't cover punitive damages generally, and they don't cover intentional misconduct. So you sometimes have to take I think you have to take the sting off of it for your client and explain, I understand the anger, we can assert these, but you also need to at least assert claims that would trigger coverage. And the fact that we see it, and I just saw one this week, makes me think that discussion is not going on, because it doesn't make any sense to me why you wouldn't want to hook in the insurance company, because in the case I'm thinking about, the general thought is that the attorney was negligent in the manner in which he handled the real estate transaction, but yet the only claim in the complaint is that the attorney engaged in fraud for which treble damages are being sought. It's just not helpful. You're not helping your client as the plaintiff by doing that. Make a recovery, because if there's no insurance coverage, there generally is going to be no money available. So anyway, and I get it if you want to include a negligence claim and a punitives claim, maybe, but right. But yeah, so that's where you just have to let cooler heads prevail and
right. That was an unfair question, but that was exactly what I was getting at, that kind of stuff. We used to have folks who come in, and one of the things I was going to talk about was, as if you're involved in an insurance defense case, your obligation is limited to the claims that are being made against the client or against the policyholder in that lawsuit. You don't have to do more. And when I worked in a firm and we were doing insurance defense work, and we would have folks, they'd be so mad at somebody else that they were involved in a car accident with, and they would want to sue them so that they could take away their driving privileges and stuff like that. And I was like, I can't help you with that. And
Yeah.
trying to explain that as an insurer, as I'm defending you through your insurance policy, and here's what I can do. You always can send people to independent counsel, right? They can hire their own lawyer to do that if you want. But we were very hesitant to go beyond the obligation of just defending that lawsuit and not necessarily making any counterclaims for anything, because it adds more burden to what you've got to do. And sometimes you talk about a conflict, then when you're bringing a counterclaim, then all of a sudden the insurance company has no interest in that counterclaim, but the policyholder does. And that's where you start to step on your own toes sometimes. So we were very hesitant to do any sort of counterclaim, or bring any sort of claim that was on behalf individually of the policyholder, because you're just overcomplicating it. And I never felt like it was my role to do that. You could offer to, put them in touch with another lawyer, but a lot of times I think it's, and we talk about it in the outline, the sort of the failure to sort of tell your policyholder, here's what the policy can do for you, all the way from, here's what I can do for you as a lawyer, here's what this policy is going to do. It's going to help pay for damages against you because of your negligence in this case. And that's a perfect thing that Brian was talking about in terms of, sort of the fraud kinds of claims, or the intentional acts kind of claims that, don't meet with the policy language, and it does sort of destroy coverage. And then right on to limits, here's all the money that they have to pay for you in case there are damages that are, levied against you. So that obligation to explain how the insurance policy works and what it can do for the policyholder is a big piece of, your overall obligation to defend the case. Excuse me. Brian, how are we doing on time? We're at 2:45 or 12:45 almost.
And I think we're only 50 minutes here, right? Or are we going till 1 o'clock?
I'm not sure if it's 50 or 1 o'clock. We can do either. I think 50 is.
Rick's, I guess 1 o'clock. We'll stay on to 1. Rick says 1 o'clock. Yeah, so
okay,
I think we could spin into, so what kind of claims have we seen? Nationally, there's an increase. I mentioned that at the beginning. I think defense firms are pretty good, I would have to say, in terms of running a conflicts check, getting things on their calendar, and making sure the answers are timely filed. And I don't know, even our best and most used defense attorneys with a case that's obscure as all get out will do a conflicts check. And so I do think the defense industry is good at that. I'll just say that, because there have been other examples where we've had claims where it's obvious there is no conflicts check that has happened when they're representing seller against buyer in the same firm, or that type of thing. But so that I think they're doing a good job on that. But where we see sometimes the problem we've encountered maybe is later down the road, maybe some discovery, failure to answer discovery, request to admits, things that maybe slid in, and occasionally there's been a counterclaim that's been unexpected that has slid back in. where the defense attorney wasn't really looking for that or attuned to that. And Joe, I don't know, I know you worked in a defense firm, but we have had claims where there's been a misdiscovery situation. The time expires to respond to requests to admit. And the very one I just mentioned where there's this counterclaim, unexpected, or maybe by an additional party, it comes in. It just, the defense attorney wasn't looking for it, and I get why, but I don't know what to be said for that other than I conclude the outline with never assume. And I think sometimes you're so used to it as a defense attorney, standard answer, I'm going to do this, that something comes a little bit off the side, like I mentioned those couple of examples. And the third one I'll say is whether to have a jury, ask for a jury or a court trial, and why one might be better than the other. I don't know if there's any good advice about how to watch for that other than what I just said. Don't assume, check everything. But
yeah, I think that I think that staying on top of the case, obviously there are times when I think discovery deadlines are one of those issues that everybody expects some professional give and take, right? Some professional courtesy. But if you wait, if discovery is due in 30 days and you pick up the phone 45 days into it and say, hey, can I have, some more time? You're better off calling on day 20 as opposed to day 40, and saying, hey, can you extend some professional courtesy here? And even if you don't, there's not a lot of teeth to some of that. If you miss requests for admissions or something like that, don't timely answer those. Those can have some teeth. You miss the deadline by which to file a response brief in a summary judgment motion or something, that can have some teeth. I know of a case where at the end of trial, one of the things the judge said at the end of the trial, is there anything to take up, before we let the jury go? And the answer was no. So the judge let the jury go. And then the defense lawyer tried to put in the insurance policy as a piece of evidence, and which you have to do, right? You've got to have evidence of the insurance policy, the limits and all that in there. And the judge said, you're too late, and let the jury go already. And even the plaintiff's counsel was, judge, we'll stipulate to what the coverage is and the policy and all that. And the judge wouldn't let him do it. So there's all those things that if you miss those deadlines, you might find yourself at odds with the insurance company. You might find yourself at odds with the policyholder too, if they get exposed beyond the limits. But all of those things have potential barbs to them for the defense lawyer. So I always took it as we did things. If there were deadlines missed or something, report it right away to the insurance company. They'll be understanding, hopefully. But I think that that might be part of the reason for the increase in claims towards defense counsel, is that maybe you've done it too many times, or like we said, there's new people inside the insurance company that don't understand that this kind of stuff they don't understand this kind of stuff happens, and they're not going to be as forgiving as you've seen in the past. But there's a constant obligation to, be staying on top of that and reporting it, both good and bad developments in a case, and all of those kinds of things, unfortunately, can be bad developments.
I was going to say that we're pretty careful. We try to be very careful. If there's a lawsuit that comes in, we don't just email it or in the old days fax, but or mail to defense counsel without having a conversation. And as I said, conflicts check some of it. But I know that of a couple whereby the attorney, there was a familiar relationship, and the carrier simply, I believe, was mail, but the attorney was out of town. And I think it's worthwhile maybe to set the tone, and the answer was that deadline was missed, but that it's, I guess the onus would fall back on the attorney to make sure that I won't accept, I mean, have a standard practice about accepting cases, and that there's not an expectation that because you did something for them before that they can send you something the day before the answer is due, and it's somehow your problem now to get an answer. And so just make sure that communication is clear about how you are going to be accepting assignments, and so you don't inadvertently get left holding the bag on something you can't even respond to.
Right. Well, in previous life, we would get lawsuits in that the the deadline to answer had already been blown by the time we get it to the insurance company. Then you're going to turn around and send it to defense counsel and say, hey, do what you can with this, right?
Yeah, fix it.
So we, always had the practice of talk to the lawyer. Hey, I'm about to send this over to you. Is it okay? That's just the way it should be done. But I'm sure there are times when people say, well, I'm going to get this out to Brian today. It's Friday afternoon. I'll check with him on Monday. It'll be good. And then you call Monday, Brian's not there, right? So now now you're scrambling to find somebody to get this thing responded to. But yeah, there's an obligation on the insurance company's part too. I mean, but but you do have situations like that arise.
Yeah, and Joe, maybe it's worth for those who maybe haven't had a program with us or are curious. And I know you have the one example probably that I'll trigger. Defense counsel just screws up. They don't get a response into a summary judgment motion. It's on me. I apologize. I didn't realize the deadline. So are you liable then 100% for the mistake, or what happens next if a claim is asserted? Yeah,
no, I mean, there are times when responding to that motion can cause you more problems as a lawyer than it would have if you just didn't respond. We have, a good example is a case where
I'm thinking of the case within the case you're going to talk about.
Right.
Yeah.
Right. So a motion for summary judgment was filed. Our lawyer didn't respond to the summary judgment motion in a timely manner. Then made a motion to enlarge time with the court so that the answer could be accepted. Ultimately put in an answer along with his motion. And the judge, had the hearing and wouldn't accept the answer. But in the end, the judge said it wouldn't have mattered if you had gotten this in on time anyway, because the law here is in favor of, the other side. So there are times, and the facts behind that case were this individual had bought a building that had housed a particular kind of business previously. That was some sort of sawmill. And his insurance agent went to look at it and was trying to get insurance to cover this new building that this person owned. And he literally could not find an insurance company to insure it because of what it had been in the past. Apparently, sawmills are very bad risks for insurance companies, and he just couldn't find a carrier to to write a policy on this particular piece of property. Well, lo and behold, the building burned down, and then that client tried to sue his insurance agent for not getting insurance. And ultimately, that insurance agent had done a really good job of documenting everything that he had done. And in the end, the judge said, you knew you didn't have insurance on this policy or on this property to begin with, and now you want to blame your agent. And, our lawyer is standing there probably knowing the exact same thing, but in the end, he didn't respond to the motion in time. So he did have a failure there, but, he could have, and I'm not sure what, real discussions he had with his client to say, we can't respond to this motion. You're dead in the water. But I've been in that position on property cases where there's property damage to a piece of property and there's not insurance coverage for it. But then you go in and you're trying to defend that in a courtroom to a judge, and the judge just looks at you shaking his head like, there's no coverage here. You know that. So you're in that weird position where you're trying to do what you can for your client, knowing that regardless of what your response is, that you're going to lose on the law because the facts are just against you. So the case in that case was that, it didn't matter whether he failed to respond to that summary judgment motion in time because he would have lost anyway. So in a malpractice case, we have the luxury of standing back and saying, we can only make this case as good as it would have been if we hadn't missed the deadlines. And in that case, deadline didn't matter. The facts of the law were against that person and they would have lost anyway. So it can be a little bit tricky at times, no doubt.
Well, Joe, I think now we're down to the final 4 minutes. Final 4.
Yeah.
Go ahead. I was going to.
Go ahead.
Well, I guess I'll just do a few takeaways, Joe, and then maybe you could add some, and then if anything else. But one thing that you cannot do as a defense attorney is say, I'm not going to even take that offer to my client. That's ridiculous. I mean, we hear that, and I actually have seen it, but that's not your role. Your role is to advise of the pros and cons, and you can say, I would never recommend paying that. That's fine, but you can't say, I'm not taking that to your client.
Right.
Your client needs to be kept reasonably informed of all offers and demands and settlements and all the factors that impact the case, because the one time you do that, maybe it works some of the time and you look tough and like a good defense attorney, but the time you don't take an offer to your client and then it blows up and there's an excess verdict, you're left holding the bag. I don't think the insurance company is. I think the defense attorney is, and it's all because you didn't advise the client of all aspects of impacting the case. So just remember, it's not your case. It's your client's, and your client may not be just the insurance company. It's probably the insurance company and John Smith or the bar owner or whoever you're representing on the other end. They need to be kept informed. Their exposure is real, and your job is to communicate. So that's a huge issue. I think being realistic with a budget to help the insurance company set reserves is a huge takeaway, and we're saying that from the benefit of sitting in the insurance company seat here. And then just communicate and collaborate, and never assume your client knows, even if they're a sophisticated client, understands the legal process. That's your job as the defense attorney to communicate in a manner in which they understand and feel involved in the process. If you do all those things, and the case may not turn out the way you expected, but as long as the communication is solid and frequent along the way, I think you're going to protect yourself and keep your client informed.
Right.
So as to avoid the claim.
Yep. Yeah, I agree with all that, Brian. And I think a piece of it is your first point of you want to communicate all those offers, demands. That's a development in the case, and you have an obligation to pass that on, not just to your policyholder, but to the insurance company, because sometimes the tough guy is the guy sitting in the insurance company, and they're just waiting for a certain piece of the case to take form and go through the steps so far. But, even when the demand goes up with no explanation, you can say to whoever, that's ridiculous. How, you've got a higher demand. No, I'm not taking that back to my client. But you have to do that. And it tells everybody else in the case how the case is developing. And for some reason it's not developing in your favor, you should be telling people that. Yeah. And to keep it as current as you can with what's where the case is at. But I think when we started, the overarching message here is communicate with your client on a level they understand. They might not understand what a motion for summary judgment is. So explain that to them and communicate as often as you can with the developments, both good and bad in these cases, and you'll be much better off at the end.
Yeah, thanks everyone. So whether you do it now or sometime down the road, if you think of a topic that you'd like Wilmick to cover in the future, we'd love to hear from you. I'm glad you took an hour to be with us, and I hope you have a great Thanksgiving week forthcoming. And that's about all I can say for today. Yep,
I'm right there with you. Thanks, everybody. Right. Let us know if we can be of any help. Good to see everybody.
Thanks, Joe.
Thank you.